Good afternoon. Welcome to the regularly scheduled meeting of the Community Development and Regulatory Services Committee for today, February 11th. I've been joined by Council Members Warsame, Reich, Fry, Quincy, and Cano. We have a relatively short agenda today. I'm first going to move the consent agenda. I'd first like to remove item number 8 for discussion and call on Councilmember Cano for a change in item number 13. Councilmember Cano.
Thank you, Madam Chair. We will be changing item number 13 to a reinstatement to Miguel Morales Diaz.
So Councilmember Cano has changed the name of the reinstatement. Thank you for that. I'll note that item number 7 are the regular licenses recommended for approval. Item number 9 is the issuance of our tax-exempt bonds for 2014. These are certain actions required to do that. Item 10 is accepting a large number of environmental remediation grant awards. 11 is our Great Streets Facade Improvement Program. 12 is the reinstatement of a rental license, as is 13. 14 is the Marshall Terrace NRP Phase 2 Neighborhood Action Plan. 15 is the Holland NRP's Phase 2 Neighborhood Action Plan, and items 16, 17, and 18 are being referred to staff. Are there any items on the consent agenda anyone else would like to pull off for discussion or question? Seeing none, I'll move the consent agenda as suggested. All in favor signify by saying aye.
Aye.
Any opposed? Those items are approved. We'll then go back to our public hearing agenda, starting with item number 1, which is a land sale at 3015 Morgan Avenue North. Ms. Oates, welcome.
Good afternoon, Madam Chair and council members. This is a proposed land sale of a property at 3015 Morgan Avenue North. This property was originally purchased under the Neighborhood Stabilization Program for land banking by the city for future development. This is located in the Jordan neighborhood. The Jordan neighborhood felt very strongly that this building was significant to the existing character and structure of the neighborhood and contacted Powderhorn resident PRG. I'm sorry, they're no longer called Powderhorn Residence Group, are they? PRG to rehabilitate this building. PRG went through, they put together a budget and felt that it was a building they could rehabilitate. This is a building that will be rehabilitated to green community standards in the city's Homeownership Works program. It will be sold under the Homeownership Works program to an income qualified buyer whose income is at or below 80% of area median. And staff is recommending the sale of this property to PRG.
Are there any questions for Ms. Oates on item number 1? Seeing none, thank you for your report. We'll open the public hearing on item number 1, which is a land sale at 3015 Morgan Avenue South. Is there anyone here to speak to this issue? Anyone? Anyone? Seeing none, I'll close the public hearing. Councilmember Quincy.
Thank you, Madam Chair. I'd like to move approval of this item, please.
Approval of item number 1 has been moved. Further comments or questions? Seeing none, all in favor signify by saying aye. Aye. Any opposed? That item is approved. We'll then move on to item number 2. Welcome, Ms. Glasper.
Thank you, Madam Chair.
Uh-oh.
I'll keep it brief. The report in front of you is regarding the pooling of tax increment revenue for the purposes of providing additional funding for the Tornado Recovery Housing Program. Staff is recommending approval of the amended and restated spending plan for tax increment financing in the tornado recovery area, and further recommending approval for appropriation increases per the information in the report. In October of 2011, the Minneapolis City Council approved special legislation permitting the use of tax increment revenue for this purpose, and last August, the Council approved the required spending plan which specified how the tax increment revenue would be spent. That spending plan has been amended and restated, permitting an additional $250,000 to be pooled and spent in the tornado recovery area. Specifically, an additional $250,000 would be allocated to the Tornado Recovery Housing Program, $225,000 for the program, and an additional $25,000 set aside for staff administrative costs. It is intended that these additional funds would be spent in our continuing effort to address tornado-damaged properties in North Minneapolis. Since the Council's original approval of the spending plan in 2012, CPET staff have inspected more than 240 tornado-damaged properties. We've worked with our partners to successfully acquire approximately 54 tornado-damaged properties. These properties had also been vacant or foreclosed and or abandoned. Some of them had also been tax forfeit. In addition to that, 23 of the tornado-damaged structures have been demolished. I apologize for my voice. I'm happy to take any questions.
Are there any questions for Ms. Galasper on item number 2? Seeing none, thank you for that extraordinary effort and that report. I will open a public hearing on item number 2, which is approving the amended and reinstated spending plan for tax increment funds in the tornado recovery area. Is there anyone here to speak to this issue? Anyone? Anyone? Seeing none, we'll close the public hearing. Councilmember Reich.
Madam Chair, I move approval.
Approval of item number 2 has been moved. Further comments, questions? Seeing none, all in favor signify by saying aye. Aye. Any opposed? That item is approved. We'll move on to item number 3. Mr. Wilson.
Thank you, Madam Chair. We have an application by North Loop Coffee LLC doing business as Dunn Brothers. They are seeking to relocate from 228 Washington North to 337 Washington North and upgrading to an on-sale wine and Class E license with strong beer up from a restaurant. This location is in the Dock Street Flats building, a newly constructed mixed-use building. The licensed premises will be located in Suite 100. North Loop Coffee is owned solely by Marty Kessel. He's the owner, and he will be the on-site manager. Indoor seating at this establishment will be for our 41 guests, and an outdoor private patio will seat 48 guests. A public hearing is required. We did notify residents and property owners within 300 feet. As of today, we have not received responses for or against this application. Staff recommendation is to approve.
Are there any questions for Mr. Wilson on item number 3? Seeing none, we'll open the public hearing on item number 3, which is an application for an on-sale and strong beer Class E license for Dunn Brothers on the 300 block of Washington Avenue North. Is there anyone here to speak to this issue? Anyone? Mr. Kessel.
Hi. Good morning. I'm Marty Kessel, said owner of North Loop Coffee, a.k.a. Dunn Brothers. We just opened for business at our new location this very morning. Without the wine and beer at this point, of course, we've got a great expanded food menu. We see the wine and beer as a wonderful addition to our offerings into the neighborhood, and I want to thank all of you for considering this item for approval.
Thank you for your comments. Anyone else here to speak to this issue? Anyone? Seeing none, we'll close the public hearing. Councilmember Frye.
I'd like to move the staff recommendation that we adopt this proposal, and we're now on to quasi-judicial hearings at this point.
One more. So this is the Dunn Brothers application. Councilmember Frye has moved approval. All in favor signify by saying aye.
Aye.
Any opposed? That is approved. We'll move on to item number 4, which is the Net Supermarket. Mr. Wilson.
Thank you, Madam Chair. Net Supermarket at 1845 Nicollet Avenue is seeking an extended hours license to allow them to be open one additional hour on the days of Sunday through Thursday. The current hours of operation authorized there are 6 a.m. to 10 p.m. Sunday through Thursday, and Friday and Saturday they have 6 a.m. to 11. They seek to be open from 6 to 11, 7 days a week. The Net Supermarket has operated at this location for over 15 years, and they have certainly been in good standings with the my department and regulatory services. A public hearing is required for this application. We did notify all persons and property owners within 300 feet. We did send 251 notices. As of today, we have received one response, and it is in support of the application. Staff recommendation is to approve this application.
Are there questions for Mr. Wilson on item number 4? Seeing none, this is a public hearing on item number 4, which is considering an application for extended hours at 1845 Nicollet Avenue South. Is there anyone here to speak to this issue? Anyone? Anyone? Seeing none, we'll close the public hearing. Councilmember Warsame. Approval has been made by Councilmember Warsami. All in favor signify by saying aye.
Aye.
Any opposed? That item is approved. We'll then move on to the last portion of our agenda today, which is the quasi-judicial hearings. Councilmember Frye.
This is a quasi-judicial hearing dealing with two particular rental licenses. This committee is limited by law to hearing argument from the property owner or the owner's representative, but is prohibited from considering any further evidence or taking any further testimony. This means that you are required to limit your comments to arguments specifically addressing the evidence or testimony introduced before the hearing officer, which is part of the record that is already before us. You may not offer, and we may not consider, any new or additional evidence. Based solely on this existing record and the arguments that the parties make today, the City Council may affirm, modify, or reverse the recommendation that is before us. So if it wasn't already exceedingly clear, no new evidence, simply the evidence that was already before the administrative law judge. I understand, staff, you have some information for us?
Right. Good afternoon, Madam Chair and Council Committee members. My name is Joanne Velde, and I am the Deputy Director of Housing Inspections Services within Regulatory Services. The property involved in this revocation action is located at 2714 4th Street North in the city of Minneapolis. This property is a single-family rental. The licensee in this matter is Mahmoud Khan, and the rental license application lists Mahmoud Khan as the owner and property manager. This matter was commenced by Regulatory Services to revoke the rental dwelling license pursuant to Section 244-1910, Licensing Subdivision 5. More than 3 repeated nuisance violations occurring at this property over a 24-month period. As of February 1st, 2013, the city had acted to abate the nuisance conditions at this property 7 times within a 24-month period. The city abated nuisance conditions on September 26, 2011, October 17, 2011, March 5, 2012, March 26, 2012, August 27, 2012, November 5, 2012, and December 31, 2012. This evidence was introduced at the administrative hearing on December 4, 2013. On February 1, 2013, a notice of director's determination of noncompliance was sent to Mr. Khan, notifying him that there had been 3 or more instances where the city abated nuisance conditions at this address. It also informed Mr. Khan that if there was any further city abated nuisance that occurs at this address, it would be grounds for revocation. On April 15, 2013, another nuisance condition was found on the property, and the city abated the nuisance condition on April 17, 2013. On August 16, 2013, a notice of revocation of the rental license was sent to Mr. Khan, providing the licensee an opportunity to appeal this action. On September 9, 2013, Mr. Khan filed a proper appeal of the revocation recommendation. On December 4, 2013, the matter came before the administrative hearing officer, Edward Backstrom. After hearing all evidence presented and the arguments were heard by the hearing officers, his conclusions and recommendations are as follows. The licensee failed to take timely and appropriate action in response to notices from the city concerning nuisance conditions. Regulatory Services and Solid Waste Division within the Public Works Department followed appropriate steps and necessary notices required under the Minneapolis Code of Ordinances. The large number of nuisance conditions at this address that was abated within 24 months by the city demonstrates that the owner licensee has failed to comply with the provisions of the licensing standard. Recommendation that the rental license held by Mahmoud Khan as owner of the property for 2714 4th Street North in Minneapolis be revoked.
Thank you. Do we have any questions? Thank you. Would a representative for Mr. Khan like to speak? You have 5 minutes.
Thank you. To the chair, council members, my name is Michael Kemp. I appear here as representative and attorney for Mr. Khan. As the council member noted, this is not the place to bring forth new evidence, nor do I intend to. However, this council is vested with the discretion under Minneapolis Code of Ordinances, Chapter 244, to amend or modify the recommendation based on the circumstances of the case. I'm not going to try and retry the evidentiary hearing, which was already held. The question is not whether this council can revoke the rental license issued to Mr. Khan for this address, but whether it should under the circumstances. As the city's own records indicate, public records indicate, Mr. Khan is the owner of dozens, in fact, over 20 different addresses. 40 different addresses, many of which have been extensively rehabbed, which is exactly what the city of Minneapolis is looking for, is developers to come in to find properties which have fallen into disrepair or become nuisance conditions and fix them up. He's done that extensively throughout the city. And so in this particular case, he did have a problem with some tenants, as the record indicates. The issue was with tenants disposing of weeds and rubbish in the yard. Now, he certainly has a legal duty to ensure that they comply with the Code of Ordinances in that respect. However, the council can take note of the fact that this was not a failure on Mr. Khan's part to do something that was required, for instance, to bring this property into code compliance. That had already happened, from being a building on the edge of demolition to something completely in compliance with the code. It was the tenants, as the record will note, who had the notice of these conditions.
Mr. Kemp, if I could just stop you right there. The previous testimony that you gave to the administrative law judge was that the trash that was left outside wasn't from the tenants, but in fact it was from other third party. Are you going back on that former testimony?
No, but the council member, there were a number of different instances where the city did abate nuisance, and some
7 over 24 months.
That's correct.
Yeah.
And in some of those instances, it was the tenants, in others it was third parties. But the question is obviously, does Mr. Khan have a legal duty to ensure that rubbish does not accumulate on this property? That's not an open question. The fact is he does have that obligation,
right,
whether it's the tenants or somebody else. But nobody has presented any evidence or even an allegation that, for instance, he was the one using the property as a dump site. I bring this up merely to point out to the council that these tenants who have since been evicted, he has surrendered his rental license, that was all actions that, while he had a legal responsibility to oversee, weren't things that he was personally doing wrong. This is intended to show the council that the revocation of his rental license may be an overly harsh remedy in this particular instance, given the circumstances. Mr. Khan has been a landlord and property owner for over 30 years in the city of Minneapolis, and during that time has had one other instance where his rental license
Mr. Kemp, I'd like you to just stay really on the record. This is only in regard to this specific parcel. Do you have any other information, or would you like to clarify any facts that are already on the record from the ALJ hearing?
Council member, no. The issues at the ALJ hearing, the testimony was developed there, and so that testimony, I certainly don't intend to add anything to it that's not already on the record there. That's obviously not the purpose of this meeting. The purpose was simply to demonstrate to the council why it can, and in this case should, in its discretion, look at Chapter 244 and say, in this particular instance, for this particular landlord, the revocation of the license, which would be a second in 30 years, would end up result in the loss of all rental licenses for 3 dozen other properties in the cities.
Again, Mr. Kemp, is there anything else regarding this specific piece of property and these specific violations?
No, Councilmember, Mr. Khan.
Mr. Khan, would you like to speak?
Yeah. The only thing I can say is that this property was condemned and I fixed it 2 years ago, brought it under complete code compliance. I spent a lot of money in fixing it. It was bought it from the Hennepin County District Court. I mean, on the tax forfeited land. After the auction, nobody bought it. I bought it, fixed it up. It was supposed to be demolished, but I took care of all the things. It's just my lapse in getting the tenants to, not to take care of some of the cleanup issues. And, I'm at fault over there. However, I feel that if I lose this license, I lose all my licenses, and I feel I'm at the mercy of the council here.
Thank you.
Nothing further to add, council member, unless the council has questions.
Any questions? Well, thank you, Mr. Kemp. Mr. Khan, I will say there are three facts that you had dead on. First, that Mr. Khan still is the owner of the property, notwithstanding any sort of contract for deed. The second is that it is his legal responsibility to make sure that that property is kept up, regardless of whether his tenants are doing it or there's some sort of third party. And the third piece is that, yes, there were more than 3 violations in the last 24 months. More than 3 violations. In fact, there were 7 violations will result in a revocation of that particular license for that particular property. And I would move that we adopt the staff recommendation and do so. Is there a second? All in favor, say aye.
Aye.
All opposed? Moving on to item number 6. Which is for the properties located at 1068 and 1072. Specifically, we're dealing with 1068 here. And give us the rundown. Thank you.
Madam Chair and council committee members, the property involved in this revocation action is located at 1068 18th Avenue Southeast in the city of Minneapolis. The property is a single-family rental. The licensee in this matter is Douglas Doty, and the rental license application lists Douglas Doty as the owner and property manager. This matter was commenced by Regulatory Services to revoke the rental license pursuant to Section 244-1910 Licensing Standards, Subdivision 7 for unpaid reinspection fees, Subdivision 11, there shall be no delinquent property taxes or assessments on the rental dwelling. 19, adverse license action may be upon good cause as authorized by Chapter 4, Section 16 of the Charter. And Subdivision 23, the licensee shall not have any unpaid fines or fees owing to the city of Minneapolis. On August 15, 2013, the department sent a notice of director's determination of noncompliance to the owner of 1068 18th Avenue Southeast, Douglas Doty. This notice provided an opportunity for the licensee to pay required fees, delinquent taxes or assessments, and administrative citations, and other cause established by Chapter 4, Section 16 of the Charter. On August 29, 2013, the department sent a notice of revocation of the rental license to Douglas Doty, providing the licensee an opportunity to appeal this action. On September 16, 2013, Mr. Doty filed a proper appeal of the revocation action. On December 4, 2013, the matter came before the Administrative Hearing Officer, Edward Backstrom. After hearing all evidence presented and the arguments were heard by the hearing officer, his conclusions and recommendations are as follows. Proper notices were sent by the department involving Mr. Doty that the department intended to request the revocation of the dwelling rental license for 1068 18th Avenue Southeast. Based on the number of housing violations occurring at the property, a large number which currently remain open, and the community concerns over the condition of the property, good cause has been shown. The recommendation that the rental dwelling license held by Douglas Doty as owner of the property for 1068 18th Avenue Southeast in Minneapolis be revoked. No action should be taken as part of this committee meeting discussion concerning the dwelling rental license held by Mr. Doty for the property address of 1072 18th Avenue Southeast.
Thank you. Just to be clear, what is the amount that's presently due and owing?
Mr. Doty did file bankruptcy, but from that bankruptcy, there was still $1,000 owed to the city.
Thank you. Councilmember Goodman?
Ms. Velde,
Yeah.
is the only issue at this point the $1,000, or are there also outstanding orders that would bring him back almost immediately?
Madam Chair, there are 58 open violations. This property has had a history of 455 violations. Those property violations are still open.
Okay.
Well, would the owner and representative like to speak?
We would. Thank you, council members.
5 minutes.
Madam Chair, council members, thank you. I'm not going to rehash the history here, but particularly what I'd like to address would be the actual hearing itself in the case of Mr. Doty. As I'm sure the council is aware, this hearing was a somewhat unusual affair in that the city missed some of its due diligence in bringing this revocation action in the first place. One of the recommendations that was not addressed previously was Judge Backstrom, Hearing Officer Backstrom did not recommend to provide, to revoke Mr. Doty's license for 1072 because the city provided improper notice to Mr. Doty. As a result of that, none of the violations that are currently outstanding can be determined as to whether they're for 1068 or 1072. One of the things that was determined in the hearing is that 1068 and 1072 are on one plot of land, but they're separate rental dwellings. It's one tax ID. So these violations that the city are saying, it is questionable whether or not we were able to address them at the hearing itself, and we don't know which actual property the violations are occurring for because they were all listed under 1068. 1062 had no violations listed for itself. So violations occurring under 1068 could be 1072, but because the city didn't do its own due diligence, we don't actually know. Additionally, the administrative hearing officer didn't actually recommend revocation under subdivision 7, 11, 19, and 23. Subdivision 7 under MCO 244, I believe, lists the licensee and the applicant shall have paid the required reinspection fees. There were no outstanding reinspection fees. And 11 is no delinquent property taxes or assessments. And while the city believed when they brought the hearing initially that there were delinquent property taxes and assessments because they had called the Department of Revenue and found out there was a confession of judgment, they hadn't looked into what the confession of judgment was a product of, which was Mr. Doty's Chapter 13 bankruptcy, and all of those back taxes and fees are in a repayment plan. The city has stayed from taking any action under USC, I'd have to say USC 523A something, which is the permanent injunction under the federal law. The open violations also weren't actually addressed at the hearing. While we were addressing whether or not Mr. Doty had taken corrective action, the city attorney objected to our specifically addressing to the point of the corrective action, as there's some question as to whether or not they have been simply closed out in the system or whether there's a systematic problem where some inspectors have told Mr. Doty that these are closed, some have remained open, and on the city records they've remained open. The city objected based on relevance, saying, and I believe I quote, "This is only about money." If it's only about money, Mr. Doty has already paid the outstanding fines, which we have proof of here today. We would request that you don't revoke his license. And at the beginning of this entire process, when Mr. Doty was made aware of this, he called the city and asked, what can I do to fix this? What do I need to pay? How can I make this better? He has been, throughout this process, attempting to rectify these problems. He was told that there was nothing he can do to fix this because of the open violations. So, in conclusion, the totality of the circumstances that Mr. Doty is addressing here and that the city should be looking at is not simply the $1,000 outstanding fine, which is what the city is requesting a revocation based on, but is my client working with the city to improve his property and to correct these violations, which his history should show. Additionally, if the city wants to revoke these licenses, they can do so properly. They can bring the proper revocation action, they can give the proper notices, and they can do so for the right reasons. And in this case, there has been, throughout this process, systematic problems that have caused a due process, have caused a violation of my client's due process rights.
Thank you. Is Mr. Larson Willie, is it?
Yes.
First question is, so you would acknowledge that there were two separate rental license applications made for these two individual properties, right?
Oh, yes.
And you would acknowledge that these two individual properties, quote unquote, sit on one parcel, right?
That is correct.
Okay, so when you make you have the application for those two individual license applications, if you can revoke one without revoking the other, right?
Yes.
And at the previous hearing with the administrative law judge, you'd acknowledge that the property for 1072, that was entirely taken off the docket, so none of the facts that we're talking about today even have to do with that, right?
No, that's incorrect.
Okay, well, explain to me how that's incorrect.
The city, there are two separate licenses, each for one permit, but when the city has been recording violations, they haven't been delineating. They haven't been saying this.
Can you stand here today and say the record shows that since 1993, there have been 62 special assessments, with 25 occurring in the last 5 years. There have also been 12 housing violations since 2013, 100 in 2012, and prior to the 450, that was prior to the 415 violations in 1993. So, I mean, are you saying that of all of those violations, 100% of them happened to 1072?
No, I'm not saying 100% of them happened to 1072.
Can you
but
delineate a figure as to what happened to one versus what happened to the other?
The only person who could do that would be the city. It's their records that are the problem.
I would agree. The only people that can do that is the city. So it's my understanding that you already paid the $1,000
Yes.
outstanding fine.
Yep.
And you do understand that the previous fines, as you correctly pointed out, they were erased from the record due to the bankruptcy. I mean, in my mind, you probably got out of a significant amount of money, and then you're still owing more.
No, he didn't get out of any money. In Chapter 13 bankruptcy, it's all repaid.
Okay. So, but he has paid the $1,000 outstanding fine. Would staff like to comment any further on some of those the contentions made?
Madam Chair, Councilmember Frey, the way the violation orders are issued from our department is when you have a separate rental license with two separate addresses that aren't connected. So these properties on this parcel, it's not a range address. So the addresses are not shared. So our system will generate our violation notice to whoever the licensee is for each address. So the violation information history stays with 1068. The violation history stays with 1072.
Thank you. So all of the violations that we presently have in our report, those would accrue to 1068?
Correct.
Thank you. Do you have any further comments? Any questions? Yes, Councilmember Reich.
Thank you, Councilmember Frey. To me, the staff has outlined a very clear pattern. That's certainly the underlying basis for their recommendation to revoke, and I would move to uphold their recommendation based on the facts before us.
Councilmember Reich has moved to uphold the staff recommendation. All in favor say aye.
Aye.
All opposed? We've adopted the staff recommendation. Councilmember Goodman.
We are at the conclusion of the quasi-judicial hearing portion of the agenda. I will note our next meeting is on February 25th. Seeing no further business before us, we are adjourned.
Madam Chair?
Oh, no, we have to talk about item number 8.
Correct.
Councilmember Reich has a previous major engagement and is unable to be here for the conversation with regard to item number 8. But if staff could give us a brief report on the issues involving item number 8.
Thank you, Madam Chair. The City of Minneapolis is hosting the 2014 Major League Baseball All-Star Game this year. With such a major event, there's extensive planning that goes into such a major event. We will be in the national spotlight. We anticipate, if we did not have a resolution, something like that is before you, that is called a clean zone resolution, that will assist us regulating some of the temporary vending and entertainment activity that's expected to hit Minneapolis. We need to plan in conjunction with Major League Baseball for a myriad of events that are planned already, and we need to coordinate all of those events to make sure that our traffic control, our police, our homeland security all know exactly what's going on at every corner. I encourage you to adopt this resolution. It will greatly help us. It does only affect temporary permits or licenses that are in use for such events. It will not affect anybody who has an annual business license in the city, such as our food vendors, food trucks, pedicabs, taxi cabs, things like that. And guess I'll hold for any questions.
Are there any questions for Mr. Wilson? I think he's addressed the questions we had raised earlier by clarifying these would be to not issue any temporary permits going forward. And he did note that the dates are from July 5th through July 20th, which was a second question we had raised. So my questions have been answered. Does anyone else have questions? Seeing none, I'll move the staff recommendation on item number 8. All in favor signify by saying aye.
Aye.
Any opposed? That item is approved. Seeing no further business before us, now we're adjourned.